Justice of the Appellate Division 4th Department. Hearing, all persons having business before this court will draw near and give their attendance to the judge.
Thank you. Please be seated. The first case on the calendar today for argument is People v. Ross 91. Judge Kainer is recused on this case.
Good morning, and may it please the court.
Counselor, if I could just have you hold up a minute. We're waiting for opposing counsel who has just appeared, so you may commence. Thank you.
Good morning, and may it please the court. Parker McKay on behalf of Mr. Ross. Your Honors, this case has always been about the failure to investigate witnesses, and I think it's significant that every single stage in the briefing, in the post-hearing, through the appeal, through the leave application, that people have always tried to move this into the realm of tactical considerations. And that's significant because that's where 99 out of 100 IAC claims go to die. Tactics of an attorney are typically never second guessed. Here, this court's already decided Everson, and it's almost factually identical. The record established that the defense attorney knew about a specific witness and he didn't do anything about it, reasoning, I didn't need to because I made the decision he wouldn't be relevant. Here, the undisputed record establishes that the defense counsel knew about at least one, if not two of the witnesses. Furthermore, these were witnesses these aren't pulled out of thin air. These aren't bystanders. These are people that the defense attorney should have easily been able to figure out were there because Mr. Ross, he goes to his mother's house to get the gun. This all occurs at his mother's house. His mother's present. His mother's name comes up in the trial testimony. His niece lived at the same house. So knowing that information, he never bothered to go talk to the mother, bothered to go talk to the niece. And at every stage, the people have argued, well, defense counsel did a lot of other things. He traveled on a weekend to go see a different witness. And that's ultimately what the trial court reasoned too. He did all of these things, and the sum total of that is meaningful representation.
Well, your claim has been narrowed from, it started out as the trial lawyer was ineffective for failing to call these witnesses.
Yes.
Now it's the lawyer was ineffective for failing to investigate them. Do I have that right? Your claim is a little narrower now? Well,
so when it started as a pro se thing, I think it was not the clearest claim, but what the record establishes, it's not only failure to call the witnesses, because that's more of a strategic and tactical consideration. It is the failure to even investigate them.
Right, because that's what your brief focuses on. Yeah. And you make a good point. Like, what strategy would there be not to at least talk to them, not to at least find out what their testimony might be, right? That's your claim. There's no strategic reason not to investigate them.
Correct.
But to grant your client a new trial there's another step that has to be made, is the witness's testimony who weren't investigated, if they were to testify at trial, would have to be probative. The trial judge would have to believe their testimony. They have to show up at the hearing. One of them did here. The other one was deceased. And the trial court evidently didn't believe her testimony. So what do we do there? Does your client get a new trial because his trial lawyer failed to investigate a witness whose testimony the trial court doesn't believe at the hearing?
He does. And the reason is that judgment by the trial judge, he's usurping the power of the finder of fact. Ultimately, in a second trial, the witness might be called, the jury doesn't believe them. But
right. In your view, at the hearing, there's no credibility decisions the court can make at the 440 hearing. Those should be reserved for the jury at trial.
Correct.
That's your position.
Yes.
Is there any case law on that? Because if you're right, then a defendant could get a new trial almost at will. You could get somebody to say under oath, hey, I have some testimony and I was never interviewed. Even if the testimony is preposterous at the hearing, even if it makes no sense and they're impeached right and left and center, that defendant's entitled to a new trial because, hey, maybe the jury will believe him. I'm not saying you're wrong. I'm just asking if you have any authority for that proposition, which would open the door to retrial after retrial after retrial.
I don't judge. I think, and certainly there is a sliding scale. Somewhere the testimony is going to be preposterous, but less than that. Here we have very identified witnesses that are in the discovery. They're known there. And the judge's credibility finding is not made so much on observations, but based on the fact, why didn't you come forward sooner? And that's obviously something that a trial jury can look at to say, well, here's why we don't believe what you would have perceived on that date. I think what's so strange about this case is that not only are these witnesses sort of identified in all the discovery, but the trial counsel, when he testifies in the hearing, he says, my theory of the case was always the contrast between Mr. Ross's statement and what the victim says. Yet he pursues an entirely different line of argument in his closing. He now turns and says, well, the gun wasn't operable. The gun was never fired. There's no medical records to prove an attempted murder, which is never needed for an attempted murder anyway. And the witnesses would have supported and corroborated Mr. Ross's original statement, which says, I fired the gun in the air. And that's, I think most attorneys, if you look at this, that's the obvious defense here. So I agree that in the extreme, there could be somewhat preposterous evidence and a witness comes forward and said, no, I came out of nowhere. I saw this and here I am. It was 8 years later after the trial saying this. This is much different because these are the witnesses who were there. They corroborate the original written statement. So there's a hook back to what the evidence was at the time of the original
fact that the witnesses waited, they were related to the defendant. They sat through the trial, didn't say anything about I want to testify. They sat through the post-trial motions, through the appeals. Only after quorum nobis was denied years and years later did they say, oh, I had testimony to give. That doesn't make it incredible as a matter of law, but you're saying that's an issue that the trial court shouldn't have considered in determining whether to believe the person or not. We should have reserved that for the jury. So
I believe so, Judge, because ultimately this turns just like the case of Everson on what the defense attorney did, and the hearing court's decision does everything to avoid that. And same thing with the people's submissions. They never talk about any of the cases about what happens when a defense attorney doesn't look into the witness. They never even cross that step. So the credibility determinations made here, they feel very much like a judge trying to avoid the main point of deciding, well, it's pretty clear and it's undisputed in the record, this attorney did not look into this.
Go ahead. As far as the justice presiding's concern about this being, other cases down the road, any criminal defendant, this case is a little bit different insofar as that the defense attorney knew about these two witnesses, knew they were in the household. That's evident from the record itself. So this isn't a situation where two witnesses come out of the blue years later.
No, one is absolutely conceded in the record that he knew about him. He had the mother's name in his notes. That was absolutely conceded. And he said,
that was the question I was going to ask.
Yeah.
The niece's name never appears in Mr. Spitler's notes at all.
No, it does not. However,
well, why am I at error for not investigating this witness?
Because, well, number one, her testimony, or I'm sorry,
She's not in the notes at all. I mean, what the indication, meaning that Mr. Ross has not indicated to him that this is a witness you should be investigating.
So that between defense counsel and attorney, I think is a credibility issue to determine about the hearing court what was provided. But
you add that to the fact that the niece sat through the trial, sat through the appeal, sat through the motions as Justice Lindley has indicated, and then all of a sudden 6 years later, oh yeah, I got some relevant exculpatory testimony here. Why didn't Mr. Spitler ask me about that? Why,
Well, and we tried to get as far as we could into the hearing of what happened back in 2011, but be that as it may, the niece is, I believe she comes up in trial, and I mean, she's in the discovery. I mean, it's very evident that these are the people who live in the house.
She's in the audience. I mean, she shouldn't be in the audience if she's got to testify, right?
I'm saying that when Mr. Spitler went back and looked at everything, it's very evident that she was a recipient witness at the scene. This is a scene where most people seem to know each other back in, I think it was 2011 when the incident occurs on Shepherd Street. They all know each other. And from there, it's pretty easy to reason because all three of those people live together in the same house. So this is not a bystander that comes by years later and somebody, let's say something was said like, oh, there was a gentleman with a gray hoodie on the street and never figured out who he was, but I know he saw this. This is not that case. These are the three people who lived together at that time in the same house where the incident occurred. And
could you remind me again, what was your client's explanation for why he didn't raise this issue? Your client had complained about other lawyers. Two assigned lawyers had been removed by the court. And he was very vocal, we'll put it that way, okay? at the hearings, every place. He's not shy about expressing his opinion. It seemed like the hearing court here, the judge, looking at it to the defendant, well, why didn't you raise this issue to your lawyer? You're sitting there at trial, you know your mother and the other witness, family members who have this testimony, and you just sit silently. You don't bring it up in your pro se 330 motion. You don't bring it up at any point in time. Did your client have a explanation for his silence?
I believe at one point he did try to raise the issue. There was another issue. There's a question whether it was ever made part of the record, and I don't fully understand it, but there was I think between attorneys number 2 and 3, he makes a motion to recuse, I'm sorry, to have Mr. Spiller withdrawn as counsel and replaced. And he's adamant he makes some of this issue in the general sense before the court about he's not looking into my witnesses. Now, at the hearing testimony, my recollection is that he says, it took me a lot to learn about this stuff. I mean, this is a gentleman who has a lengthy history of involvement in the criminal justice system. And as the court put it mildly, he's not easy to deal with. And I very vividly recall he says in the testimony, it took me years to figure this out. He did 2 pro se court notices.
It took him years to figure out that his mother was an exculpatory witness who wasn't called to trial.
On what the procedure was to do that, because that wouldn't be relevant to a direct appeal if it's off the record.
Okay.
So I think, as best I've always understood it, it's a gentleman learning over time how to do this. And then ultimately he's appointed counsel. We run the hearing and there's absolutely no dispute on what happened.
All right. Anything further?
No, Your Honors.
Thank you, Counsel. Ms. Healy?
May it please the court, Harmony Healy on behalf of the people. I think that the disagreement that I have with defense counsel and defense counsel's arguments are that I don't think that the court found that a failure to investigate 2 witnesses would not necessarily in and of itself be an effective assistance of counsel. I think the court found that the witnesses that testified were not credible, and therefore defendant did not meet his burden to establish that they had the information, that they were actually exculpatory witnesses, and B, that the information had been given to defense counsel, and C, that he failed to act upon it. I think that there were a lot of reasons why the court was having these issues with their credibility, and Justice Lindley, you went through quite a lot of them. But the fact that they both sat through trial, they both were very active with the defendant. They all lived together. If they really truly had this exculpatory information, they would have come at some point forward, at least during the trial, and said, but that's not how it was. And that never happened. And defendant would have said, but that's not how it was. And they can tell you that, but that never happened.
But Mr. McKay's point, how do you respond to his point that those are credibility determinations, not for the court at the 440 hearing, but for the jury at trial?
I think that
He suggests that a defendant can get a new trial for failure to investigate clients who the trial court doesn't believe.
so. I don't think that's
his
the case.
position.
I don't think that that's the case, because in a 440-10, the defendant bears the burden of proof, and he has to establish beyond a preponderance of the evidence each of the elements of what he's claiming. And if he didn't establish that these people had exculpatory information, that the names and phone numbers were given to defense counsel, and that defense counsel actually failed to contact them, and the way that he tried to establish that was by testifying himself, putting in the affidavit of his mother, and putting in the testimony of his niece. But the court found that that wasn't credible. And so you can't just make that accusation and not have demonstrated that you've been able to meet your burden. They didn't meet the burden because he found that they weren't credible. And also, I guess you could say that that might be a consideration with respect to how their testimony and what their allegations, how they differed from the physical evidence that was found at the scene, as well as the 911 call. That could potentially be a question for the jury, but you still have to believe that they had the information, that defense counsel had the information, and that defense counsel didn't act on it. And I think the reason why we're going through such such extensive steps on the investigation that defense counsel did undertake makes it not reasonable that defense counsel wouldn't have at the trial said, oh, these are the people that you said could exculpate you. Let me talk to them. They were present at the hearings, they were present at the trial, yet he went 500 or 200 miles on a Saturday to investigate a potential witness. And that witness wasn't able to end up testifying, but he took all these steps. He spent all this time and his investigation was meticulous. So the fact that they're saying that this person who's present at trial, he never interviewed that person, that doesn't make any sense. It flies in.
You would agree, I think, would you not, that the proposed testimony of the two witnesses, well, one affidavit and one testimony, it's not outlandish. That he shot the gun in the air, seeing that the victim claimed that he got shot, he got hit with a bullet in the stomach area, but it hit his cell phone that was in his pocket and that spared his life. Yet nobody could find, he says he discarded his sweatshirt and the gun or the cell phone. The police shortly thereafter couldn't find either one. So their testimony that the defendant fired in the air isn't outrageous, right? I mean, it's not inconceivable that that's what happened. I think that's Mr. McKay's point.
I think there are portions of the testimony that were inconceivable, and that's where it gets. For example, I think that they said that he fired twice in the air, which matched the defendant's statement, what he said. And the shells that were found at the scene, as well as the number of shots that were on the 911 call, those didn't match. So it's inconsistent with the physical evidence. Also, the placing of the casings didn't match what they were saying either. And that version of the story already went in through defendant's statement because that was put into evidence by the people. So, and that then wasn't subject to cross-examination because it was just put in that way. But I do think that what they had to testify about was inconsistent with the physical evidence that was found at the crime. But to your point, Justice Lindley, I think that they are interested witnesses and they have motivation to be untruthful, and the court was there to watch the niece testify and expressly concluded that her testimony wasn't credible. And the credibility determinations, those should be left to the discretion of the court.
That's really what it comes down to. Can the court make it or should it reserve it for the jury? We'll take a look at that. Thank you.
Yeah, I understand that part, but I still think that he has to meet those prongs. And because the court found that they weren't credible, then they found that he didn't meet the prongs of failing. I guess I feel like defense counsel is starting at the point of it was proven by the record that this information was turned over. It was proven by the record that defense counsel failed to act on it. And I disagree with that statement. I understand that the mother's phone number was located in his notes, but none of the niece's contact information was located in the notes. And again, to your point, they were at trial and they were involved actively throughout this whole entire proceeding. So to say that it was established that those two things happened, I don't think that that's true. You're asking a defense counsel who has tried many cases in between now and then to make a specific recollection, and he was not able to do so. But the only time that phone number was listed in his notes was in the very initial kind of like dump of information that was done in the first setting.
All right, thank you.
Thank you.
Case 93 is next on for argument. People versus Reed. Case 93. Good morning, Counselor.
Good morning, Your Honors. May it please the court. I want to emphasize this morning that I strongly feel that Mr. Reed should be considered for youthful offender adjudication, or if not, at least a sentence reduction. I think it's clear, the factors are laid out in the briefs. I don't want to take a ton of time going through them one by one, but this is a crime of reckless risk-taking, which is exactly characteristic of youth. It may be a relatively extreme event with terrible consequences, but it's not completely unlike something that many teenagers might do, whether it's risk-taking in the form of driving recklessly, skiing recklessly on a mountain, getting drunk at a party and doing something crazy. And this time, the consequences are terrible, but it is a characteristic crime of youth. It's also clear that he was encouraged and influenced by older.
Was the actions that he took afterwards reckless as well?
They were
Damaging the car?
not reckless. They were intentional, but they're rash in the sense that that's also characteristic of youth.
They're attempting to hide
Yeah.
that an event happened, right?
I think it's pretty normal for a youth.
It's
to be worried about
normal to do that.
consequences. I think it's pretty normal to not want.
He's 18 years old, correct?
He's 18-year-old with a 21-year-old and a 37-year-old. The 37-year-old who had been his girlfriend, and a terrible.
Is that reckless?
older woman. It was intentional. But it was rash.
Just have a 37-year-old girlfriend? Is that reckless then?
What's that?
Are you saying it's reckless to have a 37-year-old girlfriend?
The driving was reckless, Your Honor. The actions after that were intentional but rash and influenced by the pressure of the circumstances.
How's it rash to conceal the evidence of crime?
It's a high
Rather
pressure,
heinous.
you're reacting to a high pressured situation, in the
Well,
moment, a moment of extreme fear.
Well, there was days, at least a day or
One day.
that went by,
was one day.
where he damaged the vehicle to make it look as though something else happened, wasn't involved in this hit and run. And then sold it to a salvage yard and it was then crushed.
Together with
Self-
his older role models.
Right.
There was the next day.
And then he never admitted involvement, correct?
He fully admitted involvement as
Wow.
soon as the police confronted him with the evidence.
Yeah, once the evidence was put in front of him. So he denied any involvement until the video came forward.
Yes.
And then he even in the pre-sentence report, he wasn't really all that interested in admitting to it.
I believe the probation officer recorded that he became, I don't remember the exact wording, but emotional or troubled speaking about it, which I think it doesn't suggest that he was not willing to speak about it or that he was, it suggests that it was emotional. And this is an extremely trying circumstance for an 18-year-old to be dealing with.
Do you care to be heard with respect to the development of the human brain, and at what age is it become fully formed? And there's some science there that you may have referred to in your.
Yes, absolutely. I mean, this has been accepted in Supreme Court case law and in our own state's case law for quite some time. And since that has been recognized in the cases cited in the brief, the evidence is the medical or neurological evidence has developed further. Which is, there are characteristics of youth through at least 18, but the evidence now shows through the early 20s that the brain is still developing, which makes youth more susceptible to influence, which I think this is certainly a case of in this case, and more prone to rash, reckless, risk-taking behavior, not able to judge the consequences of their actions fully, think through.
I have a question, Counsel.
Yes.
There was YO adjudication on an assault.
Correct.
Okay. When did that happen? When did the crime actually occur? When did the plea occur?
The record is difficult, doesn't develop that. And I could try to develop more information, but the record shows a date of the April 15th in the PSI. That's April 15th of the same year that this, which is 2021, the year of the accident.
Wasn't it after the accident?
It would be after the accident, before the indictment.
But there's no facts in the record or the PSR about whom he assaulted with what instrument, if any, injuries, but it was pled down to a misdemeanor.
It was pled down to a misdemeanor and then a youthful offender adjudication, which makes him still eligible for a YO in this case.
So was that assault after this accident? Was that something that was rash and reckless as well?
What the only information in the record that we have is defense counsel's statement about that crime during the sentencing proceeding, when defense counsel said that there was a man in his grandmother's garage lighting things on fire, and that's who he assaulted. I believe he said with a piece of wood. We don't know how serious the injury are. We don't know what the confrontation between this adult male and Mr. Reed looked like before and how unreasonable this person was being. So I would suggest that it probably was rash. I would suggest it probably was intentional as well, but I don't know what kind of circumstances would have prompted this. But obviously the court who sentenced him believed it was worthy of a youthful offender adjudication in that case.
The last question for me at least is, if your client, if we were to grant your client YO status,
Mhm.
he's been in prison now for 3 years.
Mhm.
The maximum for a YO is less than that, 1 1/3 to 4, I believe. So if we were to grant that request, he gets out. But it's not like he got away with 3 years in prison for when he's 18 is not getting away with no punishment,
Correct.
I guess is your point. It would be, we're looking at it differently than the trial court perhaps.
Yes.
He's already got 3 and he couldn't get 3 if the trial court gave him YO. And that's why you're asking us to exercise our own discretion,
Correct.
even if we don't find an abuse of discretion by the trial.
That's right. Yes, it would essentially result in him being let out right away. And obviously, you know, I think he's a 3-year punishment, a 3-year incarceratory term for an 18-year-old youth is very substantial, especially when he has never had any term of incarceration in his past. The other YO adjudication is the only thing found in his record. Obviously, if the court felt that, you know, more comfortable with the idea of him having parole supervision for some period of time, a reduction in the sentence would result in that. Might be released right away, but he'd have some time on parole supervision afterwards.
Anything further?
I do want to be heard on the fee waiver issue because this would only come up if it was not a YO adjudication. But 2021, the legislature adopted this fee waiver provision for youths under the age of 2021. And the intent, I think, is really clearly stated that, you know, this is not a form of punishment. It's a form of revenue collection for the state. And the legislature made a decision that it is not worth collecting these fees on the backs of youth in poverty, that it creates more problems, and the state has other means of doing this. And there's a severe discrepancy right now between what's going on up here and downstate.
Right. How does it work if there's, the fees are not waived and somebody puts money into his commissary? Does the state take that? Is that how it works?
You know, I'm not sure the workings.
That's my understanding of how it works. If a family member gives them money and
Right.
they take that.
Okay.
And I guess your argument is he really has no family here. This guy has no parents.
Actually, Your Honor, I should be clear.
Parents involved, I guess.
Actually, his mother is here in the court today. So they are, you know, there's been trouble, there's been absences throughout his youth. There are periods of incarceration, really disruptive for a kid in his middle school and teenage years, but he still does have family that loves him and wants to see him home.
Because they were both involved in the CCA or the crime mitigation report,
yes.
correct?
Right, in the mitigation report. Both his father and his mother were interviewed in that.
But he would not be eligible for the fee waiver if she didn't get the YO. Is that correct?
No, if he got the YO, it would be automatic. Now under the new legislation, there would be no need, it would be a mandatory waiver. Without the YO, it's a discretionary measure. And there's some prongs in the statute. It'd say, you know, if it would work at unreasonable hardship on defendant or their family, or would, you know, make reentry more difficult, more burdensome. And, you know, the first department granted one of these last week. The second department granted 4 in the month of December.
Yeah, it seems like in all those cases, the people concede it.
Yeah.
We don't have that quite yet, but we're going to be here also momentarily. But we understand your point. We've read all those cases.
Yeah. I will just say that the second department, all those 4 in December were all in the interest of justice, not preserved. Right. So I just think the DA's consent, you know, I think it's a relevant factor, certainly, but it shouldn't be used to override legislative intent, and the court has to exercise its discretion as well. Thank you.
Thank you.
Thank you.
Morning, Your Honors. Ryan Ash for the People. As far as conceding issues, I wasn't the author of the brief, but I believe the People's position on the fee waiver issue was that it wasn't properly raised to the lower court. And in any event, the court took those factors into consideration when it denied YO. On the YO
today, you don't I'm not asking you whether you consent to it, but do you oppose the request?
We would, yeah, we would oppose the request. My recollection of the probation report is that defendant had, prior job employment and things like that, before this crime. So it's not like, I understand the fact that, his upbringing might have been tumultuous, but this isn't a situation where he's directly in poverty. And once again, I'm not entirely familiar with the facts of the probation report.
About the YO issue.
On the issue of the YO, we would submit that the sentencing court didn't abuse its discretion. The court gave a thorough explanation on the record, even where by statute it's not required to. The court actually abided by probation's recommendation that he not receive a YO. And I also disagree with the characterization of this as a rash decision. As Justice Montour noted, this is a chain of conduct. It's not necessarily one instance where defendant immediately started expressing remorse. This is an instance where he started calculating, and whether or not he had other people with him, he was participating in a course of conduct that ultimately was intended to cover up the crime. And he did get charged, and I believe pled guilty to all the counts in the indictment, not just the manslaughter count. And of course, the mitigation report naturally contains only positive information if it is based on information from him and his parents. The probation report is more of a holistic, both sides. I wouldn't necessarily go so far as say unbiased, but certainly it's a more accounting of both sides of the situation.
What do you say about the brain maturation process, that young people's brain doesn't mature fully until they're about 20, 21, sometimes older? And when you're influenced by older people, and then you admit and you show remorse and you say you're sorry and you express a desire to do better, how do you respond to that?
I think that's definitely, the scientific literature on that is not disputable, at least from a bird's eye view. But in this particular case, I again think that it wasn't necessarily just one mistake he made. This is someone who made multiple decisions throughout the course of, I believe, over 24 hours while this was happening, then didn't immediately, it's not like he presented himself to the police department and said, this is something that I want to take responsibility for.
But even the situation with damaging the car and selling it to salvage, he was with the older person, wasn't he?
Right.
So we don't know if it was his idea to do that or the older person.
Well, he acknowledged responsibility when he did plead guilty to covering up, I think, leaving the scene of a crime where a death occurred and covering up the crime. So I think ultimately that, yes, he is 18, I believe. He received a 4 to 12 year indeterminate sentence. And so the leniency doesn't only, he received leniency when he pled guilty. That's a natural, people can plead guilty for any number of reasons. One of them is to obtain a more lenient sentence. And he's well within his, ability to get the 4-year end of the sentence when he is determined whether or not he's eligible for release. And I don't think necessarily that we should treat this as a 12-year determinate sentence. I think that it's one factor of the YO adjudication is what he's going to get. And he was told he was going to get 4 to 12 probably when he pled.
So the cousin who was 21, correct?
I believe
I think he was
so. It's about,
21.
maybe a 2
So
years.
he received
Yeah.
3 to 9 years, right?
Right.
Okay, that's all.
Yeah. I would obviously for the record.
I apologize, I should know this. How fast, I know they were drag racing down J Street
Right.
and he hit the victim was on a bicycle and went airborne quite a distance in the air and died. Do we know the speeds? Is there any evidence of how fast?
I don't know this. I personally do not know what the record says about the speeds, but he pled guilty to the conduct in the charging, in the plea.
It just seems it's not irrelevant if he's going 60,
Right.
which is speeding, or if he's going 100. We've had cases, people going over 100. That's a
I think,
little more blameworthy than somebody going 60, 65, 70.
I'm not certain the damage that the victim actually received. I believe he died from his injuries, not
Yes.
instantly on impact. So I I assume that wouldn't mean he's in, excess of 120 or so, that wouldn't make sense, but I'm not sure exactly what language was in the plea colloquy here that he admitted to the conduct, but they did go through an admission of the conduct. And if your other doesn't have any other questions, I'll rest in the briefs. Thank you.
Thank you. The next case for argument is 96 People versus Jason Perry.
Morning, may it please the court. Dave Jurgens for Jason Perry. We're asking for dismissal of count 5, offering a false instrument in first degree on 2 different grounds. Point 1, we're asking for dismissal because there's a lack of proof, 2 elements required for this felony. There's no, certainly there's proof that Mr. Perry knew that the document in question was a deed, but there's no proof that he knew that this deed had a false statement that was created by the notary. There's no proof that Mr. Perry prepared this deed, that he signed the deed, that he read the certificate of acknowledgement either before or after the notary signed it. There's no proof that anyone told him that the notary had created a false statement, and the facts of the case were that he went to the law office, was speaking to the real estate paralegal who presumably prepared the deed, gave the deed to the notary who signed it, handed it back. As she's handing it back to him, she asks, well, where is she? Ariel King, the person who signed the
And he
deed.
grabbed it and he left.
Well, he answered the question. He said that,
But he grabbed the paper and left before she could even.
well, I don't think the record supports that he grabbed it. I think she handed it to him. He took it and he left. And at that point, the notary made no statement to him indicating that, wait a minute, this is an improper notarization. And there's no proof that Mr. Perry had any background such that he would know the legal rules for proper notarization. And I think it's important, to the contrary, he presented the deed at the lawyer's office to the notary in the presence of the real estate paralegal. And I believe that that's strong evidence that Mr. Perry did not know that the notary was doing anything wrong by signing the deed. The record also lacks proof that Mr. Perry intended to defraud the Monroe County clerk. I think that primarily flows from the lack of proof of guilty knowledge. I'd also note that it's important that there were no witnesses called from the Monroe County Clerk's office that would have laid a factual basis for a claim that he intended to defraud them. There was nothing about the procedures in the Monroe County Clerk's office that they would have rejected an unnotarized deed. The record's just silent on that. So we're asking the court, in the interest of justice or as part of its weight review, to dismiss the charge because the record lacks proof on these 2 essential elements. I would just note that there's a substantial risk that an innocent man was convicted of a felony, a crime he didn't commit. And this was a bench trial where the attorney brought a motion to set aside the verdict. That didn't preserve the issue for this court's review, but certainly the issue was presented to the trial court and the trial court made a ruling. Under point 2, the second ground for dismissal is a 30-30 violation.
Before we get started with that, could I ask you a couple questions on that?
Sure.
This case commenced before the effective date of the new discovery law, Article 245.
It did.
And on December 23rd of 2019, before the effective date, the Assistant District Attorney announces readiness for trial on the record prior to the law coming into effect, right?
I don't believe my recollection of the record is that was either established. Also importantly, it was never argued.
Correct. It wasn't argued. That's where I'm going here because I have the transcript here and Jake Ark was the Assistant District Attorney and he states, as they used to always do, whether it was a legal fix or not, people are ready for trial. Okay. That's how it used to be. Nobody ever questioned whether they were actually ready for trial, and 99% of the time they were not ready for trial, but that's what the law said. You just say we're ready for trial and that's enough. So he says that. Excuse me, but what date was that? December 23rd, 2019. I think it was at the arraignment on the indictment. before Judge
Okay.
Bazan.
Okay.
So he says he's ready for trial. Then, of course, the new laws took effect. He thought, just like we thought here at the appellate court, we thought the new discovery laws required you to state readiness and file a COC again after January 1st. The Court of Appeals reversed us on that, Alvin King. So on the facts, this is Alvin King. You have a statement of readiness before the statute took effect. It's not challenged. The validity of that's not challenged. And the Court of Appeals said in King, in this situation, because the new statute takes effect, it doesn't render invalid the statement that was valid previous, right? So, but as you say, so this is a little different. If that's correct, my reading of the transcript's correct, this is an Alvin King situation where the Court of Appeals would say, doesn't necessarily say the new discovery laws don't apply. It just says you don't become unready because the new statute came into effect. But what's different about this case is that the assistant DA below assumed the new law applied, right?
Correct.
Didn't make any Alvin King arguments. And now on appeal, we don't see an Alvin King argument. So what are we to do with that issue?
I believe I raised in my brief that the Alvin King issue was not preserved by the people, and there's no basis for this court to affirm on that basis, on that unpreserved issue.
So we would assume the statute applies. We would just ignore the fact that it actually doesn't apply because the people didn't realize it didn't apply.
Well,
I'm not saying that that's wrong, but as I looked for cases on this, this case called People versus Grant from the Third Department. I don't know if you have any cases where it's a similar situation.
I don't have cases off the top of my head that are directly on point. I believe I was relying upon the fact that if the people didn't make the argument in the trial court and everyone assumed that the new automatic discovery statute applied, that was the basis for how the motion was going to be determined. And as I argued in my brief here, the motion set forth sworn allegations of fact that there was 11 months of unexcused delay, and the people in response to the motion didn't contest or controvert any of the allegations. They
There's a
didn't.
clear discovery violation. I think even the trial judge, I think Mr. Ark acknowledged, and there was a sanction imposed. But your argument is that, as in Gaskin, it's not a sanction under 245-80. It's a 30-30 issue.
Yeah.
You don't get the prejudice and all that. Should we, a lot of these cases, we remit for a determination of due diligence. And if there's no due diligence, then to start counting time on 30-30. Why wouldn't we do that?
Because the defense put in sworn allegations of fact that supported the 30-30 motion, and the people didn't controvert any of those allegations. So under the statute, the court would necessarily have to decide the motion on the papers, summarily granting it for the defendant. There was no basis for remittal because there was no basis for the court to order a hearing on any factual issue. There was no factual disputes.
In your brief, in the reply brief, you characterized Gaskin as saying the Supreme Court failed to consider other arguments made by the people that could have provided an adequate basis for the 30-30 motion. And you argue that this case is different. And I agree with you. In this case, there weren't other arguments proffered. From what the people said at oral argument here, I don't see a due diligence argument really being made, or of a discovery sanction type argument being made.
Yes.
Ultimately was what it was. The question I have for you, though, I went back and I took a look at Gaskin. I don't know if they made any other arguments in Gaskin either. Do you know where you got that from in the brief?
I would assume from my reading
something in the
of
record. I mean, Gaskin's not a particularly long decision. It's just
my reading of Gaskin was that there was some factual or legal issue that was put into dispute by the people that the court never resolved, and that would have been the basis for the remittal.
Okay.
The reason why I don't think remittal is appropriate here is there was no basis in the original court to even order a hearing on the 30-30 motion, because the only thing the prosecutor argued was that dismissal is a harsh remedy. Don't dismiss. That's it.
The only other thing here is that a little bit unique is the records that were ultimately produced. It came from the victim, not from the police department. So we don't know if those emails were the same emails referred to Investigator Trubia's report.
That's another important point, is that I don't think the people were ever ready for trial in this case because they didn't supply the documentation that was in the possession of the Brighton Police Department that they should have known about, because it was in a Monroe County Sheriff's report that clearly stated, even gave a case number, and they offered to turn over emails directly from the victim that may not necessarily have been the same thing that was in the possession of the police. So they were never ready.
Did the defendant argue that below? It's clear from the record that the people said, we're just made aware of this. I got the emails from the victim. It sounds like the defense counsel remained silent at that point. Had defense counsel come forward and said, and again, the whole basis of preservation, and said, oh, we don't accept those. You have to, well, then maybe they would have found them.
If the prosecutor turned around and in response to the motion said, here's what the Brighton police had, and handed it to defense counsel, they still would have been too late, because they would have been beyond the 6 months period they had to be ready.
In your view, it's irrelevant what the subject matter. They could have, of the emails, they could have been talking about the weather. They could have been talking about their dog. They could have been, prejudice doesn't come into play here at 30-30.
It's evidence that wasn't disclosed. It was clearly relevant to the subject matter of the case, because it was noted in a police report, and it apparently had relevance to the 4 counts on which Mr. Perry was acquitted.
With respect, let's assume that we agree with you on that. The people don't get a second bite at the apple on due diligence. What about the time calculation? Of course, there could be a discovery violation and there's sanctions on a 245-80, but you want speedy trial dismissal, which means somebody has to start counting days. It has to be more than 6 months. If we strike the COC, which was January 8th of 2020, strike that, how much time is charged? I didn't see anybody making to make any analysis of what time's charged, because sometimes excludable. I looked there and it seems like the defense was asking for an adjournment for motions. That arguably would be excluded. Your argument is going to be that it wasn't caused, it didn't cause the people's unreadiness. Okay, we've had that argument a lot. But we have to wrestle with that somehow, or do we remit it to the trial court to wrestle with that?
I would say there's no wrestling needed here, because the people never raised a factual dispute. If they had put in sworn response saying that these periods should have been excludable and the court didn't resolve that, then remittal would be appropriate. But here, I think the motion should have been granted on the papers. There should have been a summary dismissal.
The sanction imposed here was more than just preclusion of those emails. Wasn't it also that there was a recorded phone call that was made from the victim to the defendant, and that was precluded too, was it not? That seemed to be a legitimate sanction. I mean, that had some teeth to it. I don't know about the email.
And if the people were still within their 6-month period for trial readiness, then it would be appropriate to look at, they're late on discovery, what sanctions should be imposed. But when they're beyond the 6-month period, when they have to be actually ready to proceed with the trial, the remedy is dismissal.
Anything further?
No,
Thank you.
Good morning again, Your Honors. Ryan Ash for the people. Regarding the weight of the evidence in this case, people would argue that the knowledge of the deed's contents can be shown by the circumstances. And that's really, we can't prove that he read it, because that's information that's solely within the purview of the defendant, and the defendant can't be called as a people's witness. That's why we show it through other circumstances. In this case, where he presented it to a notary that he had prior experience with. The
notary testified at trial also, and also wasn't there, they had a relationship, correct?
Yeah, he was a customer of the law firm, is my understanding. And that can be, that can also be a counter argument to that he didn't know the rules about notarying. I think that the notary testified that he had been there several times before, having having her notarize things for him. And also the fact that he received a benefit from this being notarized can also impute both knowledge and intent. I can't really think of another reason why he would have something notarized if it wasn't to benefit him, if he was just running an errand for someone else. That doesn't even comport with the facts here because he was the person who received his property. As for the intent, I line out in my brief that simply being a monetary benefit from the state doesn't have to be the only way you can show intent to defraud. You can show intent to defraud by receiving an official record that shows you are the owner of the property. And I think that's exactly what happened here. Your Honor had a lot of questions on the 3030 issue. So if you have something specific, I would love to answer directly.
Do you dispute that there was a discovery violation? Not necessarily that could result in speedy trial dismissal, but a discovery violation.
With the emails?
Yeah.
I think, right, they were entitled to automatic disclosure because they were noted in the police report.
They were in possession. So possession is not an issue here. They were in
the argument might
police
be
department. So that was it. What's that?
The argument might be relevance.
Yes. So relevance. And we don't know what the emails say, right? Because they're not part of the record.
Right. I believe my understanding from what I gleaned from the record, or if they might, I think they're not part of the record because they were
precluded. Yeah.
Yeah. I think they were just about the recorded phone call. And then the recorded phone call, if anything, had the actually incriminating statements or incriminating evidence on it. And that was precluded as well because the court mostly treated this as a discovery violation. It said, the 3030 motion was made essentially on the eve of trial, if not the day of trial, and was made returnable the day of trial. The people didn't have that much of an opportunity at all, really, to develop a comprehensive.
Well, the court,
But
yeah,
the adjournment could have requested an adjournment, couldn't they?
and the court actually offered that.
Well, and then the people chose to respond orally.
Right.
And then now the argument is that the people conceded some issues, but I just don't think that's the case at all, just because they responded orally. The oral argument there was responding to defendant's points. And that's why, yes, the people didn't make necessarily every argument that they could have made at that point about, the pre-2019 readiness, but at the same time, they're responding to the defendant's points. The court, yes, Your Honor?
No, I just had a question. How did you meet your burden of establishing what time was excluded for purposes of the 3030? Isn't that your burden? Isn't it the people's burden?
We met our burden because the initial COC was filed within the proper amount of time. I believe for a misdemeanor, it's 30 days or 60 days. And
this was a felony, right?
This was a
Oh, it's a
felony.
felony. Okay, so then within the 6 months, it was, I believe it was rather early though.
Yes,
It was even within the
January
30
January
days.
8th of, he
Yeah.
was arraigned in December 23rd.
And that was-
was January 8th. Yeah.
And that was naturally following the December 23rd, I believe, 2019 appearance where they did stay on the record, we're ready. But I believe wasn't there a little bit of an exchange where the court and the people said there's going to be new discovery?
Well, grand jury minutes. He asked for, Mr. Ark asked for 35 days for the grand jury minutes if I'm hearing you right, are you suggesting that you admit possession element? Because they were in the possession of the Brighton Police Department, which therefore constructively is the people. So that's.
I cannot dispute that the report said we received emails.
Right. So
I don't know the actual facts of what.
Possession's out the window and flown away.
I can't sit here and argue that the people,
Right.
that there's any information that's not true.
You're arguing relevance. And we don't know what the emails said. So are you suggesting it should be remitted to have, I don't think the defense knows what the email said. We all suspect what they say. They referred to the recorded phone call that was precluded, but should it be remitted for determination by Judge Vazana on that prong of the discovery?
Well, that I believe the preclusion and the contents of the email were more directed at prejudice, which is the analysis under the discovery sanctions.
Yeah.
So I think a remittal here would be appropriate if you concluded that the court did not entertain the correct analysis and didn't go through the due diligence analysis and instead did the prejudice, which I would dispute. I think that the court made two separate analysis and denied the 30-30 motion, I believe that they said, on the arguments of counsel, and then went on to the prejudice.
Actually, I agree.
Yeah, it sounded like the DA, the reason why it wasn't fleshed out is he didn't care about the emails. He could have cared less about those emails. So
Well,
he said, go ahead and suppress those. I don't care.
With the prejudice standard and the ultimate discovery sanctions, I think that ultimately they were planning on going to trial without presenting that as evidence.
And what about, last question, King?
Right.
Seems to apply, but you're not relying on it. What do we do with that?
I'm obviously construed by what happened at the trial court. I would prefer you to, if you feel like it's applicable, affirm on that basis, but ultimately
It's unpreserved, but it's not like one of these issues that they could have countered him. There's nothing you can say to make it apply, the new law apply retroactively. So sometimes we reach unpreserved issues, but that's out there. We got to wrestle with that one too.
Yeah, I would honestly defer to the court in how it views the record and the people's statement of readiness in 2019 as to pose. I don't know how unequivocal that exact statement was, or if they were waiting on the discovery obligations. So if the court doesn't have any other questions, I'll recommend brief. Thank you.
Thank you. Case 97, people versus Derek Marsh. Counsel is arguing virtually on that, both sides.
Good morning, Your Honors. May it please the court, Bhavya Gupte for Appellant Derek Marsh. Today, I will address point 1 of my brief. Here, the evidence was insufficient to establish Mr. Marsh's guilt under accessorial liability, and his conviction of assault was against the weight of the evidence. In this case, the people failed to prove beyond a reasonable doubt that Mr. Marsh shared the co-defendant's intent and had a community of purpose with the co-defendant to cause the complainant's death using a ligature. It was undisputed, and in fact conclusively determined, that the co-defendant caused the complainant's death by strangling him using a dangerous instrument, which in this case was stipulated as a ligature. Mr. Marsh was not responsible for cause of death. He did not participate in the strangulation. The people alleged his guilt solely under accessorial liability, that he intentionally aided the co-defendant in commission of the assault. Here, the people were required to prove beyond a reasonable doubt that Mr. Marsh knowingly participated and continued to participate in the assault, even after the co-defendant's intentions to use the ligature were clear. The people did not meet their burden. Their theory for Mr. Marsh's guilt under accessorial liability lacked competent evidence. They alleged that Mr. Marsh assisted the co-defendant in strangling the complainant by causing injuries that contributed to the complainant's death. There was no proof linking Mr. Marsh to these injuries. The evidence did not establish Mr. Marsh's involvement in the assault.
Well, I think the assistant district attorney is going to be saying in a few moments that they're relying on your client's statements, recorded statements to the police, during which he admits that he punched and kicked the victim multiple times. We know that the injuries, the coroner said 21 blunt force injuries to the head and face, fractured ribs, which the coroner said is not easy to do. You have to use a lot of force to do that, and his spleen was ruptured. So they're relying on your client's own statements. This is what I did during this altercation while the co-defendant was strangling him with a belt, and it looked like some women's leggings of some sort. So they're relying on your client's own words for aiding and abetting. And the other thing that your client said was, while the victim was being strangled, he had a knife in his hand and your client kicked the knife out. So they're saying your client assisted, made it easier for the co-defendant to cause serious physical injury with the ligature. How do you address all of those issues regarding client statements?
Your Honor, I guess to begin with, the people's allegation. In fact, the entire case against Mr. Marsh revolved around their allegation that Mr. Marsh's police statements were untruthful. In fact, Mr. Marsh's police statements consistently established his limited involvement. They only established that he was involved in a brief altercation, where the complainant unexpectedly attacked him, upon which Mr. Marsh punched him in the face. I believe he said he punched him in the face 3 times. He did not admit to kicking him in the head. He did not admit to, and nowhere did he admit to repeatedly kicking and punching the complainant.
He didn't at first, but his story evolved a bit when he was confronted with a co-defendant statement, and then he said he kicked him every which way. But it does seem, I'll grant you this, the co-defendant didn't testify at trial. The victim tragically could not testify at trial. Nobody else was in the room. So it really comes down to the weight and sufficiency of the evidence of your client's statement to the police. Could I skip ahead a little bit here to an issue that concerns me and perhaps other members of the panel? Issue number 6 deals with the Miranda issue. Probably wasn't on the top of your agenda to argue today, so my apologies if I'm catching you unprepared. But your client is brought in for questioning by investigator Root. We know what happened because it's all videotaped. Your client's 30 years old, no criminal record. The investigator says to him, does not read him the Miranda warnings for some reason. We don't see that very often. He hands him a piece of paper and says, can you read and write okay? And it says, yeah. He says, so the investigator hands him a piece of paper with the Miranda warnings and said, read the first one here to me. He hands it, read the first one to me. We have the sheet here. There's a lot more than just the first line. The investigator then walks out of view. I think he goes make a copy or something. So he's not even listening. Your client reads it out loud, the first 2 warnings out of many. And then he immediately picks up the pen and signs it. Your argument on appeal in point 6 is he was not adequately advised of the Miranda rights and therefore he did not voluntarily, knowingly, intelligently waive them. Could we hear argument from you on that?
Your Honor, I would have to reference my briefs.
All right. Well, do I have the facts right?
Yes, he did. The sort of conversation before him signing the Miranda warnings were very confusing. It was a very conversational setting. It was almost like he was just being brought in, brought in to answer some questions. It could not be like ascertained that Mr. Marsh knew, could have known that he required counsel in this situation.
You are arguing in your brief, the people did not prove beyond a reasonable doubt. That's the burden we're talking about. Beyond the reasonable doubt that the statements were voluntarily made, and you also challenge the adequacy of the warnings. It seems to be a legitimate issue on the surface. I'm curious what opposing counsel has to say, but the way I watched the video a number of times, your client signs a waiver after 4.8 seconds. After he's never read the warnings.
He's not read the warnings yet.
He reads the first one out loud, first 2 out loud. We can hear it. Then he picks up the pen and he signs it. Your point is that's not a valid waiver
That is correct. That did not establish a valid waiver simply because he did not knowingly waive his rights to defend himself or right to a counsel in this case.
There should be suppression of every last statement he made, which is the whole basis of his conviction.
Yes, Your Honor. That essentially what the argument would be, to suppress his statements. And I guess,
Okay.
but
All
I
right,
guess,
well,
sorry.
Yeah. We, anything else you want to add to that? I know I'm kind of catching you unaware. That was buried in your brief. Perhaps in retrospect, maybe should have been earlier asserted, but hindsight's 2020. So maybe we will move on and hear from Ms. Ryman, her views of the Miranda issue, unless you have anything else you want to share with us.
I do, yes, Your Honor, I think the whole point is Mr. Marsh's statements. This entire case is about his statements. And I think it's important here to sort of acknowledge and state that there was not, his statements were consistent, and the people did improperly argue that they were untruthful. They did not meet the burden. There was nothing in the record to suggest that they were untruthful. In fact, if Your Honor, if you, the record does not nowhere in the record does it specify this repeated kicking and punching.
Right, we're getting to the truth or falsity of them. I'm talking about the admissibility in the first place, and whether you, an investigator who does not read you the rights and has you read them themselves on a piece of paper, that's a little unusual. Now, I've seen it before where a suspect is asked to read it out loud and the officer's listening to make sure the defendant understands it, the suspect understands it. That didn't happen here. He asked him to read out loud the first one. So read the first one right there for me. Not read all the Miranda warnings, read the first one. The guy reads the first two.
Yeah.
But the investigator is not even there. He leaves with that. Then he comes back and he himself is surprised. He's like, wait a minute. You read all of those? And your client says, yeah. And then it becomes clear moments later, he in fact had not. When he was shocked to learn that, wait a minute, I can get a lawyer? So in any event, we're going to take a close look at that, and we appreciate your time this morning.
Thank you, Your Honor.
Ms. Ryman?
Yes, may it please the court, Lori Pettit-Riemann on behalf of Cattaraugus County, people of the state of New York. I would first submit with respect to the Miranda that the defendant was not clearly in custody at that time. He was not handcuffed. He was not told he was under arrest or told that he was free to leave. He was very relaxed. He was sitting in the chair, conversing with Detective Rutt. I would submit, first of all, that it was not custodial and the circumstances did not make
Why would he give him the right?
But counsel, I have a question. Didn't they bring him to the police department in custody?
No,
Didn't they
he
bring him there? He didn't
They
come there voluntarily. They brought him there in a police car, didn't they?
They went out, Detective Rutt went to where he was residing and said, hey, will you come talk with me? And this is the same street where everybody's out standing around because a body was found. He said, hey, will you come talk to me? And the defendant said, sure. He came and talked to him. He didn't have a car. So that's not unusual in places like this where they say, okay, yeah, I'll come with you. Took a ride with the police officer a couple blocks away to the police department and interviewed him. I don't think that was
He sat in the
custodial.
front. He sat in the front passenger seat, which would also kind of, but the only thing I will say is your own police officer at the time that he's giving warnings says, look, if this was in your yard, I wouldn't have to give you the warnings, but you were here in the police station, so I'm going to give you these warnings.
Correct. And an abundance of caution. Also, I think it was pretty clear that the defendant knew how to read and that he understood. I also, if the court were to find that it was custodial, I think that the Cattaraugus County Court's decision was very thorough in evaluating it. And I also would submit that was not the primary piece of evidence. Again, there were multiple things that put him there with the co-defendant in addition to his statements.
But we're talking about suppression. We can get to harmless error and all that later, but You're arguing he wasn't in custody, therefore Miranda wasn't required. So what if he actually didn't read it to him? But that argument, my understanding is, was not made by the people below. So it's unpreserved. And more importantly, the trial judge did not deny the motion on that ground. So under LaFontaine and Concepcion, we not sure we could affirm on lack of, he's outside custody at that time. Could we talk a minute about to see if my reading of the video is consistent with yours? The defendant is handed the sheet. You agree the investigator didn't read him his Miranda rights?
Correct.
Little unusual, but okay. The defendant's handed a piece of paper. The investigator says, read that first one right there for me. Right? You agree with that?
Yes.
He doesn't say read all your rights, read the first one. And the defendant takes him up on it, he reads the first one, and then he immediately picks up the sign, all within 5 seconds of being handed the piece of paper. You with me on that?
Yes.
Okay. Now, do you think it's, I've read those rights. I mean, unless this guy reads at the speed of light, there's no evidence he's a speed reader of any sort, but it's just physically impossible for him to read all those words. I mean, we counted them all up. We know he only read like 11% of the words on that piece of paper. How can we conclude beyond a reasonable doubt, okay, it's your burden, not his, that he actually was advised of the rights in writing and he understood them?
Well, he started to read them, and most 30-year-old adults, 30-some-year-olds, know what the rights are. He had every opportunity to read them if he wanted. And then he did ask questions later, do I need a lawyer?
Right. That was only because the police officer, understandably, investigator was like, wait a minute. He comes back, he leaves, he doesn't even hear. Says, you read all of those? Like, that is a really good question by an investigator, because it's impossible that he read them. So then the guy goes, he doesn't, and the investigator directs him to the bottom. There's a whole nother section of the waiver of rights that he didn't read. And he said, here, read this too. The defendant starts reading that. He's like, wait a minute. I need a lawyer here. Like, obviously he didn't read them prior to that, but it's a very, it seems to be not by the book on a murder case. You don't get many murder cases in Salamanca. It seemed not the most careful administration to assure the defendant knows his rights. But I'm open to being persuaded otherwise.
I think the video says for itself. It speaks for itself, indicating that there's no way he could have read all this within the less than 5 seconds period before he picked up the paper, read the first one, and says, I got it, and signed it. There's no way he read all of them.
So what's the alternative? Does he say, we're going to sit here for 10 minutes before I let you sign this?
Well, the alternative
think it was
is
clearly
he does what
understood.
99.999% of other officers do, is they have a card, they read you the Miranda rights.
Correct, but
It's not a huge ask on a murder case. It takes less than a minute.
Not a huge ask on any case.
Yeah,
Well,
a
and-
misdemeanor case.
I would also submit at this point, the officer didn't know that the defendant was a suspect. He had been seen associating with the other defendant. At this point, it's almost, I would consider a deposition until they start talking. He doesn't know what he knows or that he's a murder suspect for sure.
So it's not interrogation then. It's he's out of custody. It's not interrogation. No Miranda. None of that's preserved, and that wasn't what the trial judge ruled on. So we got Concepcion present, but we'll take a look at very closely at those arguments.
Okay, thank you.
Anything further?
None from me.
All right. Thank you very much. Number 98 is People versus Allen.
Good morning, Fabian Santacopi for Mr. Allen. I'd like to discuss point 1 today. First, I would like to address the prosecution's argument that point 1 has been forfeited. I think this court has made clear that issues of competency survive a plea of guilty. They survive a valid waiver of appeal, and they may even be raised on appeal when not preserved. Many of this court's decisions are in my brief. I could just move to the merits unless you'd like me to go further. The conviction of a defendant, while he is legally
But the real issue here is whether or not the court abused its discretion.
That's true. But what I actually want to focus on is in looking back at my brief, there's a paragraph within point one that I kind of want to focus mostly on, which is if this court is not going to go far enough to say that the lower court abuses discretion by failing to conduct a competency hearing sua sponte, that the court erred by not conducting.
Where in any of the conversation of the 23 pages of the transcript of the day of the plea, where is your client exhibiting any evidence of incompetency? He answers every question. He's had opportunities to speak to his attorney. He says he understands everything. He's aware of the fact that he's going to be deported. He's aware of the fact that there were prior incompetency situations. Obviously, they were brought to attention by the defense counsel or the prosecutor, and the judge continues to ask the questions. He affords your client the opportunity to speak to his attorney, which he does on occasion or two. He does all of that, and there's where in those 23 pages does it show that Mr. Allen is somehow now again incompetent, where he's not able to assist his attorney in the defense?
So I think first and foremost, those are all yes or no questions. And also, I do think you need to look at the history.
I think he said, yes, I do understand. They weren't just yes or no, one syllable type.
All of his responses were yes or no. I went and looked at it yesterday.
I read it again this morning.
Right. And do you disagree that all of his responses, other than I think okay ones?
Is that a question for me or what?
Yeah, so I think he says, okay, yes or no. But I think in this case, what I was getting at is that if the court's not going to go that far as to say the lower court abuses discretion by failing to conduct a competency hearing prior to Mr. Allen's plea to 3 counts of murder, I do think the trial court in this case specifically has an obligation to conduct a more searching inquiry regarding Mr. Allen's competency prior to the plea, because the record has significant doubt upon his fitness to proceed over 6 years. This is not a case where a 730 exam was not conducted. This is not a case where my client was never found incompetent. 3 730 exams are conducted, 2 of which he's found incompetent, 1 of which there's no conclusion. He's found incompetent a total of 3 times if you count the competency hearing.
Well,
2 of those times.
Those were instances too where the defense counsel or the prosecutor brought to the attention of the court that, hey, my client's eating his feces, that's probably not ready. It's probably not ready to stand trial today. In those instances where that was brought forward. Now the judge in this instance starts asking questions, basically goes through all the rights that he's waiving, goes through the fact that there were prior incompetency proceedings. Yes, there were. Yes, his answer was yes, I understand there were, whatever it might have been in that regard. It may be a yes or no situation, but there's no, at those points in time, the judge is asking these questions and really there's nothing that says to him, okay, maybe you're not competent.
And I understand that that's cutting against my argument, but I do think that in this case, because of those 6 years, and what I was also getting at is, he's found incompetent a total of 3 times. After the first 2, he's later found fit to proceed, and then again incompetent. And the 3rd time, not right before he pleads, because we have the 7-month gap, which yes, I understand is due to COVID. But on the 3rd time, he's found fit to proceed. He doesn't come to court for 7 months. And then his first court appearance, he immediately is pleading to 3 counts of murder. It doesn't look right. It doesn't look good. I'm not saying it's enough.
Counsel, isn't there a presumption of competency amongst all defendants and all people that come to court?
Yes, there is. And I think this case presents perhaps an exception to that when someone's incompetent on and off for 6 years.
But capacity is fluid as a period, isn't it? Capacity.
The judge even says that after the plea's taken that, in the interest of justice, we're accepting this plea because who knows what the future may have. But I think because of this history, because of this 6 years, immediately coming to court and pleading guilty to 3 counts of murder after being found competent 7 months ago is concerning. And what I'm asking, I suppose, is for a more searching inquiry at the very least.
But his lawyer request a competency hearing at 7:30.
Not he requested it one of the times
before the plea, but at this instance.
No, but he also did not.
The people request one.
No, that's why it goes to discretion of the court.
Well, right. And if there's a presumption of competency and there's nothing in the record to alert the court that there may be an issue with respect to capacity, then why is it wrong to go forward?
I suppose I disagree that there's nothing in the record saying that. You're saying there's nothing in the record from the plea. I'm saying that we still, I think we can't ignore those 6 years. And in addition, the case law is, did they have ample opportunity to interact and observe the defendant? And did the judge have that after he's certified competent for the third time and before he pleads? No, he just comes in and pleads.
That's why the judge relies on the presumption.
Well,
Capacity.
and I understand that. I guess I suppose I am looking for you guys to see it. You see, in this case, it's different. I don't think we can presume Mr. Allen competent. I guess that's what I'm saying in essence. And I think what cuts also Mr. Allen's favor here, at least in the record, is we're missing that last competency report. I had a very the district attorney and I went back and forth. Their file didn't have it either. The court was unhelpful. The trial court was unhelpful. We don't have that missing piece, that last report that explains why this time he is. And obviously, 7 months later, he comes in and pleads guilty to, murder and 3 counts of murder, without, yes, there was questioning. I think there were 2 questions that had to do with competency. And again, they were yes or no questions. And I guess, again, not I guess, but what I'm asking for is that I think in this case, because of the history, the court, there should be an obligation for the court to do more of a searching inquiry. Yes, this would, I suppose, be a new rule, but I think Mr. Allen is different. And I don't want to go off the records, but I do want to say that, in my brief, obviously we put in their DIN numbers. You can look them up in Doc's custody. Mr. Allen has gone back to Central New York Psychiatric Center. He was returned in July of 2023. So this is, ongoing.
I think Justice Noack was.
Oh, I'm sorry.
That's all right. I'm way over here on the side. If separate and apart from the plea, the colloquy, your understanding is that there was a report. There was a report that was attached at some point to that 1-page form. It's the same form that we've seen over and over
There
again.
had to be. There's no way there wasn't, but I don't know where it is.
And that would have been received by the court at some point, around the
March
March
4th,
date,
March of 2020. Yes.
about 6 months before the plea because of the pandemic.
Right. So he was supposed to be brought to court March 26th of 2020, but then the pandemic happens and then he comes in September 23rd for the first time since being